Good afternoon, everyone. It's good to see that so many of you were able to attend my presentation. I see some of my colleagues here who already knows me, but let me introduce myself. I am Audrius Cininas, a judge of Vilnius District Court. It's the biggest court of Lithuania, more than 100 judges. As you know, I'll be speaking about the possibilities of planning of regular judges' activities, reducing all the waste time, as well as unpredictability, which is facing judges in their everyday activities. Some superstitions which is still resilient among the brotherhood of the lawyers, as well as brotherhood of politicians, will be discussed too. The basic ideas of the presentation are inspired by the theory of constraints. A theory of constraints exploits the idea that the system performance is limited by one weakest link in it. That's why by finding and improving the weakest link in the system, we can improve the performance of the whole system. And as we all know, widely accepted that in the court system, the weakest link in the chain is a judge himself. Theory of constraints categories. However, not being a professional manager, I intend to show things not from manager, but from lawyer's point of view. That's why I don't strictly to theory of constraints terminology and using it as little as it possible. I believe that the principle of TOC cannot be applied as straightforward as it used to do in regular industry sectors. We need a different approach. Here we see the main categories of the theory of constraints. That's inventory, work in process, throughput, drum buffer rope, and demand. Some of those categories we'll discuss in our presentation, in my presentation. And here's a short content of my presentation. I'm going to start with a few comments on challenges facing court system worldwide. Then we will discuss of quality standards and the goal of the judicial system. Then we will try to discover the starting point. I mean most common attributes of the different judicial procedures in different countries and legal systems. Then we will talk about the judge's inventory. We'll discuss the issue of number of running work-in-progress cases, how this number affects case lead time, and how this affects the length of intervals between the hearings. I'll say a few words about the issue of the scheduling of the big case in this part too. Next, I will share with you some ideas on the case throughput improvement, mainly by employing a time previously allocated for postponed court meetings. And finally, I'll conclude in brief how things itself are at my point of view. So, let's start the presentation. the challenges. The issues are well known, once common worldwide, and I believe they are as old as the court system itself. It means it lasts for centuries. Mr. Shimenon Past gave us detailed description of these notorious problems right here last year, and I have little to append to it, except of summarizing of most common problems. And these problems, as we see, are low flexibility of judicial procedures, autonomy of the judges and lack of managerial culture, variety and complexity of judicial procedures, conflicting interests, and dissatisfaction of public. Low flexibility of judicial proceedings. Judicial procedures are dictated by law. Judges or court administration must stick with complexity of different procedures which are dictated by the court. They have a little space to improve efficiency of case flow. For example, by managing case maturing time, case start-up time, number of work-in-progress cases. Furthermore, lawmakers believe that the simplest way to increase the throughput of finished cases is by increasing a number of work-in-progress cases and inventing even more and more new terms of different intermediate procedures within running processes. Various types of intermediate deadlines are running Lithuanian codes, like ones dictating pretrial procedures terms, intervals between hearings in the same case, or decision-making terms after the hearing was finished. These running terms concentrate on isolated procedures. Unfortunately, a judge himself has little to do with it, as long as the rhythm of his job is dictated by these overrunning rules, overrunning terms. Autonomy of the judges and lack of managerial culture. Judges are independent. Mentality of the judges is not managerial and not collaborative one. Very few countries provide for judges compulsory training for management functions of the court. Judge at court acts as one separated unit, making decisions on his own activity planning all alone, not consulting with anybody. That's why judge himself becomes a factor of unpredictability. That appears to be a problem, especially in big courts. Because the court administration has to coordinate the other court resources, such as legal IDs, secretaries of the hearing, distribution of the courtrooms, and so on. To make clear what the problem is, let me put you through a small example from my own practice. I always wondered how it could happen then 100 judges of our court shares 50 courtrooms, and we're constantly struggling with the lack of the courtrooms. While hearing takes less time than the judge's time in his own office with the kinds of paperwork. And I shared courtroom with one of my colleagues, and offered him once to share hearing time instead of the courtroom itself. I meant to have hearings on Tuesdays and Thursdays, while my counterpart would use the courtroom on the rest of work days. And guess what that was the answer? You got hearings whenever you want, and I got the hearings whenever I want. That's it. And let's realize now that you have to find consensus not with 2 of judges, but with 100 ones. So we have consensus and collaboration issue, which is not as little as it looks at first. Variety and complexity of judicial procedures worldwide. Difference of various criminal procedures may vary from country to country, but the fact is that still there is a great number of them in any taken country. Handling of such variety of different rules is a challenge for every judge on court management. It is necessary to extract some common laws, some starting points for managing of this all variety. That's where theory of constraints approach is helpful, I believe. Conflicting interests. Mr. Shimon Pass already pointed out, and everybody knows, that 50% of participants are against the system. But this is not the end of the story. Full kit issue is well known in theory of constraints. It means that you can start the hearing as long as complete kit or full kit of litigants, witnesses is gathered in the courtroom. Almost each of them, attorneys, prosecutors, experts, have their own due dates, schedules in the other judicial proceedings. These schedules look forward for months. It's difficult to find a room for hearing in acceptable terms, which is appropriate for all. It is not speaking on the other issues such as unexpected illness of some key process, but sudden request of different kinds, appeals, and so on. And as a consequence of it all, relatively long lead times, growing distrust and dissatisfaction of the public. Yes, a long lead time sometimes is a problem, and we are discussing it. But what I would like to stress is that there is another side of the story too. Courts have little to do without legislative support, which is up to lawmakers, not to the court authorities. So the issue addressed not only to the courts, but also to mostly to politicians. Recently, EC Director General for Justice unveiled the EU Justice Scoreboard, which on the regular basis will cover some basic statistical numbers about efficiency of the courts in member countries. A high-profile conference on the issue of efficiency of the court management will be hosted by EC soon. I'm looking forward for this conference if there are some realistic starting points will be found. Anyway, the good news is that policymakers realize the necessity of the efficient court management. And now, this is a little out of our subject, but let me say a few words about issue of public perception of judicial procedures, as well as public relations of the courts. Looks like in the survey, the issue in the previous survey, the issue of public perception of the courts is directly connected with the length of judicial proceedings. and we want to disagree with it. There is no direct connection between short case lead time, for example, and positive public perception of the court's activity. As we see on the screen, the number of long-leading cases in Lithuania is relatively small, while the public distrust of the judicial system is still quite high. And on the other hand, in the countries where judicial proceedings lead relatively longer, positive public perception of the courts is relatively better. What is the reason for it? I think that is not last reason for that is a poor public relations of the court, as well as offensive rhetoric from some populist policymakers, which happens occasionally, as we all know. Next, I believe that is because only a small part of pending cases becomes a subject of public interest. There are namely those vicious, long-leading, complicated, complex cases of high profile. Therefore, the picture of the court's activity is seen which is seen in public is incomplete, as it is formed by a small fraction of all pending cases. And finally, only a small part, only about 10% of population of Lithuania have personal experience at participating in any sort of judicial proceedings, while researchers of Vilnius University provide us with completely different statistic of public opinion. The research covers only the opinion of respondents who were involved in judicial proceedings and have their own personal experience, based on direct participation in any kind of judicial proceedings. The research reveals that over 75 of interviewed litigants, witnesses, and other participants are confident of the court's independence. Therefore, I believe that public perception of the court's activities is a matter not only of the court management, but court's public relations too. So now we can come back to our subject, criteria of the effectiveness. Is that a goal of the management of the court, the quality of the judgments, case lead time, and due date performance. The goal. Before speaking about criteria of effectiveness, we will describe a goal of the system. Whether it's a plant or office, the goal of both industries is to increase their profit by means of sales. Namely by sales, but not by manufacturing itself. Generally speaking, nobody interesting from the consumer side in manufacturing. Everybody is interested in very final product of the industry. As to the courts, the purpose of their existence, of course, is not to make profit. Courts are providing a public service by issuing a final rulings. The demand for this kind of production, as we all know, is virtually unlimited. As we know, that is why the courts have no any problems with sales and demand. Public in general does not care, as I said, about how long will last different intermediate judicial proceedings or how sophisticated or even cute they are. Everybody is interested into the final product of the judicial industry. It is final rulings or final decisions, as you like better. That's why the management of the courts must focus on its main goal, increasing a throughput of the judgments. of good quality, of course, rather than focusing on different kind of intermediate terms and intermediate processes. Clearly speaking, the judge has to maintain all his cases, not a single one, but all his cases, to be leaded in acceptable terms, rather than taking care of, as I said, single case, single one isolated case, and leaving aside the rest of his cases. The judge must distribute his time resources equally to all his pending cases. Therefore, defining the goal more precisely, it is to issue as much as possible rulings of good quality in acceptable terms. To issue as much as possible rulings of good quality in acceptable terms. That is what throughput in theory of constraint is about. And now a few words about criteria of effectiveness. The quality of the judgments. As I mentioned before, a quality of the judgment is essential too. Most of my colleagues may agree with me that there is not clear measure for this sort of criteria. The quality of the judgment cannot be measured not by time, not by money. Of course, such criteria can be, for example, that judgment has to meet a kind of public expectations or any sort of political issues. The judgments and law are not meant to meet public opinion or satisfy public. The quality of the judgment must be measured within the same system. I can say in advance that I don't like this criteria which I am going to introduce here either. But as long as we don't have any better, the one and only criteria for the quality of the ruling is the stability, robustness of the ruling. The first instance court ruling has to be approved only by dispute parts, by letting the judgment came into force, or by appealing before a court of appellate instance. Then the decision of appellate instance court will measure the quality of the previous decision. Of course, this criteria is not perfect, I know it, because the grounds of the repealed judgments is not necessarily related to interpretation or application of the laws. But what I would like to stress, to notice, that we don't need a we don't need an absolute static numbers. We don't need that numbers. What we need is an effect of increasing throughput on the dynamic of stability of judgments. Just for comparing, not just for looking at the single year's numbers. Talking about Lithuania, stability of rulings of Lithuanian courts looks fair. About 98% of decisions of first stage courts of Lithuania remains unchanged, or came into force without appeals. Less than 10% of the judgments of first instance courts were appealed in 2012. That means that disputing parts in general admit decisions of the courts at very first level. Case lead time. Case lead time is a source of public disappointment too. We all know that notorious expression, justice delayed is justice denied. 2030 EU Justice Scoreboard gives us some numbers on the length of the proceedings in all European Union countries. As we see on the screen, case lead time may vary significantly from country to country. Proceeding length in Lithuania, even in Lithuania, where statistics looks more than good, The length of proceedings may vary. Proceeding length in litigious cases is far above the numbers which is shown in the picture. This average numbers, I believe, includes a large number of judgments in small claims, where process is running without hearing in the courtroom. An average range of the criminal proceedings in Lithuania is similar to civil cases. And at the end, what I would like to stress, speaking on the case lead time, that not necessary improvement of the case lead time improve the throughput of the cases. I would like us to keep in mind that better case lead time not necessary is not equal to better throughput. Better case lead time is not necessarily equal to better throughput. And now, due date performance. Theory of constraints operates not with raw materials or commodities. It operates with universal units, and it's money and time. In judiciary, it means that every case must be finished in terms which were allocated for that particular case. Due date performance includes not only planning of the lead time. It also includes the planning of the number of hearings and time allocated for each hearing in the courtroom. The time is the universal measure for the case, so that the complexity of the case must be measured not by the number of litigants, witnesses, not by the number of the files or number of accused people, but namely by time. The time embraces all the factors universally. Of course, you may say it's a little tricky thing to evaluate the case complexity of the case in such way, but it's a matter of the judge's experience. I believe every judge must develop this ability. Of course, it's my personal opinion. I mean, not to look at the case like some set of the files, instead of it evaluated as a unit which will consume certain part of the judge's work time. And now, where is that special start point we should to start? As I mentioned earlier, a virtually infinite number of different judicial procedures in the different courts of different countries are running now. The manufacturing in the court has shape of letter I. It is the simplest, straightforward manufacturing way of all. That means that cases are produced on the simple production line from very beginning to the end. You take the case, put at the beginning of the production line, make necessary manipulations with it, stop the line when something unexpected is happening, and run the process again later until the very end of the line. Then you take the next case and put it on the empty line again. That's simple. But the problem is that the judges are multitaskers. They deal not with a single, but tens or even hundreds production lines simultaneously. The human can't work on 2 or more lines simultaneously. While one particular line works, the rest of them has to be halted, waiting for the time to start of each of them. And that is not the end of the story. By the law of Murphy, the 1 or more lines will start working without notice. At that particular time, when the judge is busy with manufacturing of most complicated case he has of all his cases. Is it possible to deal with it? What are the most common attributes of the judicial proceedings to start with? Despite a great variety of judicial proceedings, Most of them have common attributes, which are universal almost in all countries and all types of judicial proceedings. Common judicial proceedings consist of three main stages. It's pretrial proceedings, hearings held before the court, and decision-making stage. You may agree with me that the most time-consuming, most unpredictable, and most difficult to manage is the second stage of the judicial procedures. It's the public hearings. Using theory of constraints terminology, we can suppose that the first stage of the proceedings is a sort of inventory. Here matures the cases which are not in process yet. The cases are waiting for the appropriate time to start up, and the judge himself can control the speed and number of the cases flowing from inventory to the hearing, to the work in progress stage, work in process. This is important because the number of work in progress cases, as I said, affect the case lead time. The more work in progress cases the judge operates, the longer the lead time of each case. And now let's take a small abstract example for it. Suppose that some judge got 100 cases for hearing. Each of the cases requires 3 meetings, and each of the meetings is 2 hours long. In theory of constraints terms, the judge got the work which will take out 600 hours. This is our inventory. We can use 2 strategies for distributing of the work time. Let's name it strategy 1 and strategy 2. Strategy 2 does not nothing about theory of constraints and assumes that early start of the hearings in all cases means quick finish too. While the strategy 1 knows a bit about theory of constraints and applies distributing of the cases into 5 small fractions, 20 cases each. The size of the fraction is limited not by a judge, but by some external constraint, which prevents from setting up work in process cases to even smaller fractions and shorter intervals between hearings. So we assuming here that work days of the judge is 8 hours long. And now results. So, as we said before, strategy 2 is supposed to hold the first hearings in all 100 cases consequently. This is the first hearing by the strategy 2. This is the second. This is the final hearings in 100 cases. So, first hearings in all 100 cases consequently, then second hearings in all 100 cases, and the very final hearing again in all 100 cases. This strategy 1, as we already know, is to divide the cases into small fractions and deal with them, keeping the rest of the cases as inventory. This is our inventory. And I would not bother you with calculations, which are very simple, by the way. Just let's take a look at the results of the average lead time. What we see here is that the average lead time of the case says following strategy 1 is much shorter. The final meetings, furthermore, final meetings in each case of the fraction of the cases are marked with red color. We see here that the following Strategy 1 were finished 60% of cases by the final hearing on Strategy 2 was started. This is finished cases. By the time there were no finished cases following the Strategy 2. It means that at least 60% of Strategy 1 litigants are happier about the case lead time than the Strategy 2 litigants. Of course, it looks a little confusing that only a distributing of the time can change a case lead time so significantly, but it is. And again, I would like to remind you that increasing of the case lead time in a long time frame, in a relatively long time frame, does not affect the throughput. In this example, if you would take the full time frame, the 600 hours, we would see the throughput is the same. This is work in progress process 600 hours. The throughput is the same. Here is 100 cases and here is 100 cases too. So the throughput, managing the time distribution affects the throughput only in relatively short time frames. Of course, I'm speaking about judicial proceedings, not about regular industry sectors, which about I know virtually nothing. And then you may ask you, if it doesn't affect the throughput, why do we speaking about it? What is the importance of the work in progress cases management? There are a few reasons for it. Firstly, it helps to set the rhythm of the judge's job. Rhythm of manufacturing is a famous issue in theory of constraints. Neither judge nor court administration can control a number of incoming cases. That is a factor of uncertainty. You may be surprised, but the number of incoming cases in the court is seasonal. It varies more than 100% from month to month. This is the number of incoming litigious criminal cases at Vilnius District Court. Number of incoming cases, as we see here, swings from less than 100 cases a month to more than 200 cases a month. It gets really impossible to keep a steady pace of work without managing the inventory of the cases, by storing the cases for some time as an inventory in pretrial stage. Of course, until the better times will come, and we are sure about that better times will come in August, September, or January. By controlling the time occupied by work in progress cases, judge dictates the rhythm of the production himself, instead of letting to set it by unpredictable judicial market. In other words, the judge himself controls the drum. It's a very known name in theory of constraints. That is important, because allegedly being constraint of the judicial system, judge sets the rhythm himself, not to be overloaded by a number of incoming cases. This is precisely what recommended by theory of constraint, to keep work at steady pace of the constraint. On the other hand, not much like in common industry sectors, size of storage or size of inventory and number of maturing cases cost virtually nothing in judicial system, as courts, as we know, may not worry about such issues like demand swinging or supplies. Intervals between hearings. I mean in the same working process case. We all know the longer interval, the more you forget about that particular case. The more you forget, the more time you have to spend by restoring the circumstances of that case. A human can keep focus on the case for the time of several months if it's nothing happened up there. That is not speaking about other shortcomings such as unacceptable long lead time, probability that some of the witnesses will simply forget that they were summoned to some hearing as witnesses. Anything unexpected can happen in a relatively long period of time. This picture is based on our previous example. How the number of work in progress cases affects the length of the breaks between hearings. We see here that the break time in strategy 1 and strategy 2 differs dramatically. The break time following strategy 2 is as long as about 40 work days, while the intervals between the meetings using strategy 1 is less than 10 days. There is no doubt who is happy about the judicial proceedings and the case lead time. So my recommendation is here. Once the case is started work in process proceedings, it is necessary to keep it hot until the very end of work in progress proceedings. And it is impossible if you maintain too large number of work in process cases. Dealing with mega cases. No secret that big cases consumes a lot of judges' time. The question is how to fit big case into the routine of regular cases exchange. As big cases requires not 2 or 3 meetings as regular cases, but 10 or more. And the question is how to match the hearings of mega cases with the meetings in regular cases. And I believe it is possible by using a strategy 1 of small fractions of running work in process cases, and by evaluating pending jobs with units of time. Instead, of course, some another units like I said, number of files, number of accused persons, and similar units. Suppose we got a big criminal case which will take, as we evaluating in advance, about 80 hours of work in process time. It is 10 meetings, 8 hours long each. As we keep as little as 32 work hours of work in process cases, or 2 work weeks, this is regular cases, time allocated for regular cases. And this is time allocated for big case. So, as we keep as little as about 32 work hours of work in process cases, or 2 work weeks, we are able to appoint the first meeting in 2 weeks, which, as we understand, is unrealistic in big cases, because the constraint here is not a judge, but some external constraint out of the judicial system. It's obvious that here there is a big number of disputing parts in the big cases. Legal representatives are already appointed to the hearings in other trials. There is simply no room for another yet meeting in such short period of the time. Unlike the regular cases, the hearing dates for the big cases has to be scheduled much in advance. and the time not for one but for all planned meetings has to be allocated in the schedule. In our example, as we see here, the time for 10 meetings has to be allocated to our case on a weekly or even 2-week basis. Weekly or 2-week basis, in my opinion, is most appropriate in Lithuania for big cases. Mr. Shimon passed last year suggested a daily basis hearing for the big cases, but I believe that it's not realistic in Lithuania, as various claims, intermediate appeals from disputing parts can appear, and it takes time to solve them, as well as find possible new evidence and find missing witnesses. Therefore, in my opinion, as I said, hearing of the big criminal cases on weekly or even 2-week basis is most appropriate for Lithuanian judicial system. As you were noticed here, the Mondays, Tuesdays, Fridays are always empty in my schedule of courtroom. That's because the meetings is only a part of judge's activity, and these 3 days has to be allocated to another purposes. The empty Tuesdays, by the time, will be filled with another regular cases from the inventory, which is waiting up here in the pretrial stage. And the final question is managing of decision-making time. Now let's take a look at our picture on the screen. The last stage of the judicial process is the decision-making stage. This stage is supposed to work as a buffer for reducing of wasting time in previous working process case. The picture on the top. This is a way to increase throughput of the case. On the grounds of my own experience, I found that decision-making time and the ruling takes at least half of judge's work time. At least half. This work time of courtroom can be effectively used as a buffer. This paperwork time can be used for filling of the time which was previously allocated for postponed hearings, because there is no need for any special preparations or appointments for judges of courtroom job, for judges' paperwork. The idea of creating of such buffer looks confusing a little, because we used to think that the judge goes away for decision-making immediately after the final hearing is finished. We used to think that the time for decision-making is necessary, must be allocated next to the planned final hearing. This is not correct. Very often, judges have subsequent hearings one day, and the other day for the decision-making in number of finished cases, not in the special one. This is because we never know for sure of the date of very final hearing. The strategy of immediate decision-making generates a lot of wasted time. Suppose we have postponed hearing and no off-courtroom job. In this case, the time not for the postponed hearing is wasted, but also the time allocated for immediate decision-making is wasted too. So I believe that hearing time and time for paperwork out of courtroom has to be strictly separated, at least on daily basis. The time dedicated for decision making has to be preserved by time for buffering process. I mean for filling the time of the postponing hearings. It is necessary to accumulate sufficient amount of decision-making time, sufficient amount, to fill not only days intentionally allocated for decision-making, where in previous screen were Mondays, Thursdays and Fridays, but fill in time which was allocated previously to postponed meetings. In my opinion, it's of course only my opinion, in my own experience, work time accumulated for decision making has to be nearly equal to that allocated to work in processed cases. And now, short conclusions. The time is the unit for the case flow management. The main and unit instead of which must substitute such measures like accounting of different intermediate terms, numbers of accusations, number of files, and so on. The hearing is the constraint of the judicial process. Of course, somebody will say, what to do with the cases, with procedures where there is no hearing? Yes? I can answer you. No hearing, no constraint. Yes. Case lead time can be improving by reducing the number of pending cases. In general, I would say that a judge must keep as little as it possible work in progress cases. Keep his cases as inventory in pretrial stage and accumulate a substantial time in the last stage is as decision-making stage. And what I would like to notice once more, shorter case lead time not equal to better throughput. It can happen in relatively short time frames, but in general, case lead time can improve intervals between hearings, can improve time management, but it will not improve the throughput of the cases. But throughput can be improved by accumulating of decision-making work time. That's it. Any questions? No? So, thank you very much for your attention.